Mr. Neguse.
Thank you, Mr. Chairman. And I want to say thank you for hosting this hearing today. And I certainly am supportive of the underlying legislation. And I want to say thank you to each of the witnesses. Thank you so much for appearing today and for your very brave testimony. Professor Gillis, I'd like to point you to a 2016 letter released by the civil rights organization, the Leadership Conference on Civil and Human Rights. And in that letter, the organization says, quote, "Forced arbitration does not allow public scrutiny of alleged discrimination, nor does it allow for the creation of judicial opinions that help develop the law and provide further guidance on emerging trends. As a result, landmark civil rights laws, such as those protecting employees from race, gender, and age discrimination, have been rendered meaningless," end quote. I wonder if you could opine as to whether or not you agree with that assertion, and if so, perhaps elaborate on how protections against sexual harassment are sidelined by arbitration in terms of the conference's position.
Thank you, Congressman, for the question. I totally agree with the letter. I feel like I've written words like that in articles about the impact of forced arbitration. The reality is not that difficult to discern if claims are being shunted into a hermetically sealed, siloed, private regime where corporations write the rules, employees and consumers can't bring collective claims. There's no written decision, and despite some of the discussion, I won't call it out by name, but despite some of the discussion about how easy it is to go to court and have your arbitration clause deemed unenforceable, that's actually not the case. We've spent the last decade litigating all of these arbitration clauses in court after court. Dutifully following the Supreme Court has upheld arbitration clauses 9 times out of 10. So I think the problems are severe, and I think you're right to point out that they're particularly severe when we think about the most vulnerable groups in our society, minorities, women, low-wage workers, people who often lack political voice and for whom collective litigation is probably the only way that they're going to be able to resolve their disputes. I also just want to take a moment, although the representative is left, to just note that the discussion that was just being had is a little hard to sort of keep on the record. Post-dispute arbitration is fine. And the truth is, if employers don't have an incentive to offer it after the dispute has arisen, then I don't understand why there's an incentive beforehand that's not completely unfair and illegal, right? It's very possible, as the chairman said, that an employee and an employer could decide that they just want to resolve the dispute in arbitration once the dispute has arisen. The incentives are still there if you believe them, which is that maybe it's faster, maybe it's cheaper, and maybe the secrecy or the privacy is of benefit to both parties. I don't understand the argument that an employer suddenly won't want to offer that as an option, and I think that's wrong.
Well, I certainly share your confusion on that point. I wasn't going to address it, but I'm glad that you did, and that the chairman did as well. And I couldn't agree with you more. And not to belabor the point, but I think your summation of the various reasons why arbitration can be so flawed in terms of corporations writing the rules and victims and employees and consumers being unable to pursue collective claims, and ultimately a process devoid of any transparency is all the more reason for us to move forward with the underlying legislation. So again, I thank you for your testimony, and I thank all of the witnesses for their testimony today. And with that, I will yield back to the chairman. Yield back the balance of my time.
Gentleman yields back. Mr. Bentz.